Imagine if you made a trap beat. You really liked it, it ended up getting placed, it became a hit single, and then out of nowhere, a producer from the 90s comes out and sues you because they claim that your hi-hat bounce was invented by them and therefore they own the copyrights to the rhythm in your beat. Imagine you make a EDM beat and a house producer from the 80s comes and sues you for the 4 on the floor rhythm and some of the swing that you put in your drum pattern. You didn't sample them. You didn't remake their beat. You just made a beat that sounded like pretty much everything else in the genre, and now you're getting sued. Well, this is actually happening. It's happening to reggaeton artists. And so a lot of artists, a lot of producers, a lot of labels are being sued right now. I've talked about this before. I've covered this case before, but now there's an update. And the update really drives a couple points home, especially the point about the copyrightability of a drum pattern. People, producers, all of you love jumping in the comments and saying, you can't copyright a drum beat, you can't copyright a rhythm, you can't copyright a drum pattern. So why has this lawsuit been dragging on for so long in front of multiple judges and maybe going to trial very soon? I know a lot of producers are nervous because if this lawsuit actually works, think about the other genres, the other producers that could come out and sue tens of thousands, if not millions of artists right after this happens. Pretty crazy. So if you're curious to know what that update is, let's get right into it. I think the Suno lawsuit's a little bigger than this, but this is huge for production. We've talked about this before, to give a recap. There are 2 dancehall producers, well, the estate of one, because one of them has passed, who produced a instrumental in 1989 that pretty much defined the reggaeton sound. And then a derivative of it. So the original one is Fish Market, and then there's Pounder. And Pounder really became the quintessential reggaeton sound. It's been sampled, it's been interpolated, it's been replayed, and now they're suing virtually the entire genre of reggaeton and a lot of pop artists because they've incorporated that sound too. So the update is that effectively the judge, they're at an impasse right now. So U.S. District Judge Andre Barati Jr. declined to rule. So he hasn't made a ruling yet. This has been ongoing for well over a year, I want to say. They called it a sprawling lawsuit. It says, the judge said the sprawling lawsuit ultimately turns on dueling expert testimony, so probably musicologists, over whether the Jamaican producer's drum pattern, including kick, snare, hi-hat, and tom elements, was sufficiently original to support claims that thousands of reggaeton artists unlawfully copied it. He says, I have to decide as a matter of law for one side or the other when there's an army of experts basically shooting at each other, Barati said, referring to the numerous reports of musicologists, the plaintiffs and defendants filed to support their arguments. If the Barack Obama appointee denies both sides' requests for summary judgment, which would resolve the dispute based on undisputed facts, wild sentence, the case would proceed to a jury unless the parties settle. So this is just a crazy case. I don't think the parties are going to settle if they've been fighting like this forever, and one side wants a piece of, 1,000 songs or 1,000 artist songs. I think it's tens of thousands of songs, honestly, maybe more. And then the other side wants to not give that up. There's no way there's going to be a settlement. I don't know. What are your initial reactions to this update? Because I have some points, some lessons.
Like I'm curious to hear the lessons because I have no idea. Like I don't know what this sounds. I think it's kind of a wild thing, but it sounds like there's some legitimacy to this. I didn't know before you brought this up, obviously, that there was like a sound that resonates through the entire genre that pretty much helps define the genre. If you wouldn't have brought this up, I would have. That's a wild thing to say. Like, does that exist in any other genre? Like where?
It does actually. I would say it exists in New Orleans bounce, and I would say it exists in drum and bass.
Well, that's a very specific niche. Like, I can understand that just by the title of the genre. Like, but yeah. So I'm looking forward to hearing the learnings from this because I have no idea. Like it's interesting, but yeah, feel free.
Number one, I think the biggest takeaway, which is what you alluded to, Dame, was that number two, judges aren't musicologists or musicians. And so that's why, you see this judge expressing frustration that he doesn't know which side to believe because they're all making valid points. This lawsuit hinges on musical nuances. So of course it's dragging on because this judge doesn't make beats. This judge didn't go to college for music. He didn't go to the school of music. He doesn't know what FL Studio is. He probably isn't a dance hall fan. Maybe he is. I don't know. Number three, I'd say either way it goes, it's going to have an impact on production because to me, I mean, if you're a fan of the genre, and I am, pounder rhythm to me is what I hear in the vast majority of reggaeton songs. But this case is a lot more complicated because the plaintiffs are claiming that their original track, Fish Market, inspired pounder, and pounder was a derivative, and therefore they can sue for anyone using either their beat or a derivative of their beat. So that strikes me as much more complex and confusing than anything. Number four, and I would love this. This is I say this all the time. We talk about sampling and sample clearance. Clearance just needs to be easier because imagine if every reggaeton producer was just able from jump to streamline the process and say, you know what, I'm going to give 3 to 5% to Steelie and Clevie just to cover my ass. And that was just kind of like the statutory minimum or something. And so they accept it because that's how they have to act. It'd be like, it's like cover songs. When someone covers a song, you don't need to get clearance. You just have to negotiate, or you have to give them the agreed upon mechanical license terms and all that. Why can't we do this for sampling? I think the only reason is because sampling entails a sound recording, and who owns sound recordings? The label traditionally, and labels don't want to give up power. They want to negotiate. And then also because there may be other stuff going on given who tends to sample what genres, what people, and they want to just kind of make that more complicated. But yeah, think about that. If these two plaintiffs had just gotten 5% of every reggaeton song that was released, that would be tens of millions of dollars. They wouldn't be suing anybody. They'd be happy. They'd be generationally wealthy. So I think this is just crazy, and I'm on the edge of my seat, but I don't think we're going to get an update for a while. That these things move so slowly, and I have to imagine that a lot of labels, a lot of producers, and a lot of artists in the genre are also just kind of biting their nails, waiting to see what happens.
Wild situation for sure.